just to talk about the actual upcoming paper, the 2007 tort paper. As I said at the outset of this presentation, I have no inside information, so everyone's tuning off their computers right now. I have no crystal ball to predict exactly what's coming up in the paper. What I can do is give an overview of the tort syllabus and maybe try to narrow down your focus and maybe concentrate your mind on a little more on some of the topics you should be looking at and specifically the issues that arise within those topics. Okay? So firstly, you have to cover the general principles of negligence. Okay? It's a vast part of the course, but you have to cover it. So basically what I mean by that is the duty of care, the standard of care, and causation and damage. You have to know those. No matter what questions come up in the paper, those principles in a greater or lesser degree will come up on the examination paper. Now they mightn't come up as clear-cut as an essay question, discuss the duty of care or discuss the standard of care. But they will come up, whether it be mixed in with an employer's liability question, with a psychiatric damage question, whatever the case may be, these principles are vitally important. Taking the first then, the duty of care. The duty of care makes an intermittent appearance on the examination paper over the years. It hasn't come up in at least 2 papers, I think. It certainly wasn't on the March 2007 paper. When the duty of care comes up as a standalone question, it invariably arises as an essay question. The duty of care, as you know, deals with novel or new conceptual situations that the courts haven't dealt with before. And so by that nature, it can be very difficult for an examiner to construct a hypothetical problem question around facts that have never been litigated yet in the Irish courts. So a duty of care question tends to come on or arise in relation to discuss the development of the duty of care or discuss the role of policy in relation to the duty of care or compare the Irish approach towards the English approach in their views towards the duty of care. Effectively, what you need to know in relation to this question in summary form is, first of all, number 1, Donoghue versus Stevenson, 1932. Don't know that case, go home. You know, it is the birthplace of all modern negligence. Donoghue versus Stevenson, and elucidate from Donoghue versus Stevenson the neighbour principle, okay? And you can take 2 issues out of the neighbourhood principle, that you owe a duty of care to your neighbour. Who is your neighbour? Well, effectively, under Donoghue versus Stevenson, your neighbour is anybody whom you could see was reasonably foreseen would be injured by your negligence, okay? And 2, had a close relationship with you. Now, close relationship tends to mean a legal relationship in this context. So in other words, out of your Donoghue versus Stevenson analysis, you should take away the principle of reasonable foreseeability and proximity, those 2 issues. Moving on to the next important case, and this is summary form again, is the Annes versus London Merton Borough Council case. And the Annes decision created a schism between the Irish and English jurisdictions in relation to their approach on the duty of care. A lot of people look back on it now and say it did nothing but reiterate Donoghue versus Stevenson. What you need to know from Annes is that the Irish courts looked at the 2-stage test developed by Lord Wilberforce and said, well, all Lord Wilberforce has done in Annes is reiterate Donoghue versus Stevenson. That was the first limb. The second limb is important because it introduced for the first time public policy considerations into questions in relation to negligence. So the importance of Annes from the Irish court's point of view was that for the first time the English courts or the courts were accepting that they made decisions based on policy or politics. In other words, that law wasn't an exact legal science. So that you had reasonable foreseeability, 1, 2, proximity, and thirdly, are there any public policy reasons why we shouldn't recognise the duty of care in these circumstances? Now, if you looked at those 3 issues, foreseeability, proximity, and policy, they all mean the same thing. They're all essentially policy. And they're just merely labels that judges and courts use to hide their decisions, if you like. So they may say something's not reasonably foreseeable, and therefore we're not going to find a duty of care was owed. In actual fact, what they're actually saying is we're making a policy decision that we believe, for whatever reason, that if we impose a duty of care in these circumstances, it would be a bad thing. A good example of that is the Breslin versus Corcoran Supreme Court decision of a couple of years ago, 2003, where the judge decided, this is the case if you remember, guy leaves his car in the forecourt of a garage in Dublin, goes into the shop, leaves his keys in the ignition. Car is stolen, joyrider drives car, joyrider injures and badly injures pedestrian. Pedestrian, obviously the joyrider disappears, he's uninsured. Pedestrian brings claim against the Motor Insurance Bureau of Ireland, which basically pays out claims for uninsured driving. The Motor Insurance Bureau of Ireland can then turn and seek an indemnity from the person who was actually insured on the car. if they can prove he was negligent. So the MIBI sued the owner of the vehicle saying, you owed a duty of care to pedestrians in relation to leaving your keys in the ignition. Now in that judgment, the court said that while it was reasonably foreseeable that if you left your keys in the car of a forecourt of a busy city centre petrol station, that the car would be stolen. That was reasonably foreseeable. However, the judge decided in this particular case that the joyrider who stole that car, it was not reasonably foreseeable he would injure a pedestrian. And therefore they decided there is no duty of care. Now if you look at that question, you might say, well, I accept it's reasonably foreseeable if I leave my keys in the ignition, my car could be stolen. But equally, isn't it just as foreseeable that the person who stole my car wouldn't pay much attention to the rules of the road, and so therefore isn't it foreseeable that they would injure somebody in their driving? And therefore it was reasonably foreseeable to leave my keys in the ignition would injure a pedestrian. Okay? The best way of explaining that decision is the policy motivations behind it. You can see the Supreme Court looking at this saying, okay, what are the knock-on effects if we recognise liability in these circumstances? Do we take it to its next logical step and say that somebody parks his car outside his house at night and doesn't lock it but takes the keys away and it's stolen? He's liable for whatever the driver does. Or let's say he does lock his car, but his car is a model that's easy to break into and somebody breaks into it and steals it. Is that person going to be liable for the joyrider's negligence? So that's just an example of how the proximity, foreseeability factors work, and really they might be disguising simple policy decisions. Moving on from the Ann's decision then under the English jurisdiction, you had probably the next important case was the Capero decision, Capero Industries versus Dickman. And in that decision, 1990 House of Lords, the English House of Lords recognised that maybe their interpretation of Ann's theretofore was too liberal. In other words, they had equated proximity with foreseeability. So if you had one or the other, then a duty of care would arise unless there were public policy reasons denying recovery. The English House of Lords recognised that this was probably too liberal a formulation, and in Capero they decided to roll back from it. So they separated foreseeability and proximity and policy, but introduced a new element which became known as incrementalism. In other words, that a duty of care would not be imposed unless it was just and reasonable to do so. And what was just and reasonable? Well, that the law should expand in incremental or baby steps. In other words, it should develop on a case-by-case basis. So the duty of care wouldn't be recognised in a new situation unless there was a similar situation already decided, so that the law wouldn't leap forward in huge conceptual leaps on a principled basis, like the Irish system at that time, but rather it would move on a case-by-case basis, slowly developing. On the Irish version of this, the next decision that came along was the Ward versus McMaster Supreme Court decision, around the same time as Capero. And in that case, it seemed at that time at least that the Irish Supreme Court in the form of Justice McCarthy rejected incrementalism, and they favoured the Donoghue versus Stevenson foreseeability, proximity and policy moving forward in leaps and bounds based on a principled approach. They appeared to reject the Capero decision. I say appeared because the latest Supreme Court decision in 2003, the Glencar decision versus the Glencar Explorations versus Mayo County Council decision, has appeared to realign itself with the Capero decision in the United Kingdom. So now that in Ireland, we seem, according to Chief Justice Keen's judgment in that case, we seem to have brought ourselves back to the position in the United Kingdom of foreseeability, proximity, policy, and whether it is just and reasonable to recognise a duty of care in the given situation. So that would be the bones of your duty of care answer. As I said, tends to come up as, if it comes up by itself, tends to come up as an essay question involving a discussion of that development. Otherwise, if it comes up as a problem question, you need to use your own common sense and say, well, look, a duty of care will be recognised here. So a solicitor acts negligently towards his client. Well, you can briefly mention Donoghue versus Stevenson, briefly mention foreseeability and proximity, but common sense would tell you there that there is a recognised duty of care and you would move on to the other issues.